Age Discrimination in the Workplace by Gil Nahass and Shayan Jamaleddin.
What is ageism? Ageism is stereotyping or discriminating against individuals or groups because of their age. Employers are generally not allowed to hire, fire, or promote employees, nor decide an employee's compensation based on their age. However, it can be difficult to determine whether an employer's actions were motivated by age discrimination or by a genuine belief that another person can perform a particular job better. States have extensive complaint and fact-finding procedures to help employees determine when they have been victims of age discrimination and to assert their rights. Examples of potential age discrimination. You didn't get hired because the employer wanted a younger looking person to do the job. You received a negative job evaluation because you weren't flexible in taking on new projects. You were fired because your boss wanted to keep younger workers who are paid less. You were turned down for a promotion which went to someone younger hired from outside the company because the boss says the company needs new blood. When company layoffs are announced, most of the persons laid off were older, while younger workers with less seniority and less on-the-job experience were kept on. Before you were fired, your supervisor made age-related remarks about you, for example, calling you such as that you were over the hill or ancient. Gross v. FBL Financial Group. Facts of the case. In April of 2004, Jack Gross sued FBL Financial Services under the Age Discrimination in Employment Act, claiming he was demoted because of his age. A federal district court in Iowa found in his favor and granted him $46,945. On appeal, the United States Court of Appeals for the Eighth Circuit reversed the ruling and ordered a new trial. The court held that the instruction of the jury was improper in Mr. Gross's case. It reasoned that since Mr. Gross did not submit direct evidence that age was a deciding factor in his demotion, he was entitled to a jury instruction that put the burden of persuasion upon FBL to show that it would have demoted him regardless of his age. The question: does a plaintiff need to submit direct evidence of discrimination in an ADEA claim in order to shift the burden of persuasion to the defendant? The conclusion is no. The Supreme Court held that when an ADEA discrimination claim is presented, the responsibility of persuasion doesn't shift to the accused employer to prove that they would have taken action regardless of the plaintiff's age, even when there is evidence showing that age was a prominent factor in the decision. The court held that a petitioner must prove by a preponderance of evidence that age was the but-for cause of the litigant's actions. Justice Clarence Thomas was writing for the majority and accompanied by Chief Justice John G. Roberts and Justices Antonin G. Scalia, Anthony M. Kennedy, and Samuel A. Alito. The court referred to the ADEA's text and congressional intent that the Title VII burden shifting framework did not apply to the ADEA. Justice John Paul Stevens dissented and was accompanied by Justices David H. Souter, Ruth Bader Ginsburg, and Stephen G. Breyer. Justice Stevens argued that Congress and the court had already dismissed the but-for standard of causation in ADEA claims. Then he went on to criticize the majority for unnecessary lawmaking. Justice Breyer also introduced another opinion and was joined by Justices Souter and Ginsburg. He criticized the majority for implementing a standard which was unfit for determining complex mental processes like motive, which is mandatory in an ADEA discrimination claim. In the end, it was a 5-4 decision with a majority opinion by Clarence Thomas. Bob v. Wilkie. Facts of the case. Since 2004, petitioner Norris Bob worked as a pharmacist for the Veterans Affairs Medical Center in Bay Pines, Florida. During her time there, she helped to develop the Geriatric Pharmacotherapy Clinic, which treats older veterans with diseases or disabilities common to those who are at advanced age with military service. In 2009, pharmacy management gave Bob an advanced scope to prescribe medications without the approval of a physician, which was necessary for her position. In 2010, the VA rolled out a nationwide treatment initiative similar to the GPC Bob had helped develop. Against recommendations by Human Resources and despite requests from doctors, pharmacy management denied applications by several current module pharmacists, all females over 50, and granted applications of 2 pharmacists under 40. 2 of the female pharmacists who were rejected advancement filed equal employment opportunity complaints, and Bob provided statements and testified in support of their EEO claims. The pharmacists claimed that their non-selection purportedly for lack of advanced scopes was an excuse for discrimination, and that any justification for denying advanced scopes was pretext for discrimination as well. Bob alleged that because of her participation in the EEO process, she was denied opportunities to engage in the company's new program, and that the management forced her to consent to a schedule that was unworkable for her current department. Due to Bob's inability to meet this demand, her advanced scope was removed, which disqualified her from company advancement. Then a female pharmacist under the age of 30 without an advanced scope was chosen for the advancement opportunity. Babb brought this action under the Title VII of the Civil Rights Act and Age Discrimination and Employment Act, alleging that she fell victim to gender plus age discrimination and that the VA fought back against her for participating in protected EEO in violation of those laws. The VA was granted summary judgment by the district court on appeal to the U.S. Court of Appeals for the 11th Circuit. Babb reasoned that the district court erred in part by not giving her the opportunity to prove that the retaliation or discrimination was a motivating factor behind the VA's refusal to promote her. The lower court was affirmed by the 11th Circuit, finding itself bound by precedent that federal sector employees' claims under the ADEA and Title VII require that the litigator display retaliation or discrimination is a but-for factor in adverse personnel action.
The question: does the provision of the Age Discrimination and Employment Act of 1967 that protects federal employees aged 40 years and above from age discrimination require a plaintiff to prove that age was a but-for cause of the challenged personnel action? The conclusion was no. The federal sector provision of the Age Discrimination and Employment Act of 1967 requires that age not be taken into consideration at all in making personnel actions. But if age is indeed a but-for cause of the action, that fact may be important in determining the remedy to which the plaintiff is deserving. Justice Samuel Alito delivered the 8-1 majority opinion of the court. The relevant provision provides, quote, all personal actions affecting employees or applicants for employment who are at least 40 years of age shall be made free from any discrimination based on age. The court found the plain meaning of regulation supports the reading that age does not need to be a but-for cause of an employment decision for there to be a violation. To reach this conclusion, the court focused on several phrases as well as the syntax of the sentence. This interpretation is also consistent with the court's precedent interpreting the Fair Credit Reporting Act, the ADEA's private sector provision, and Title VII's anti-retaliation provision, because the language in these provisions is noticeably different. The court noted, however, that but-for causation is important in determining the appropriate remedy. For example, the plaintiffs cannot obtain compensatory damages without showing that age discrimination was a but-for cause of the employment decision. Remedies must be tailored to the injury, and the injury is measured in part by the causal relationship. Justice Sonia Sotomayor wrote it in an opinion in the same light of Justice Ruth Bader Ginsburg, pointing out that the court's decision does not foreclose claims arising from discriminatory processes, and that the same provision may also permit damages remedies even when the federal government engages in non-dispositive age discrimination. Justice Clarence Thomas wrote an opposing opinion, arguing that the court's reading of the statute is too broad and, quote, disrupts the settled expectations of federal employers and employees. Our third and final case is Simmers versus the Los Angeles Times. Some facts of the case: T.J. Simmers was a writer and columnist for the Los Angeles Times from 2000 to 2013. During his time at the Times, Simmers was one of the most praised columnists by his colleagues. His performance reviews were uniformly positive, frequently getting ratings of exceptional and described as a brilliant columnist. This praise even continued up until February of 2013, where the then editor-in-chief of the Times congratulated Simmers for conducting maybe the best interview with Kobe Bryant yet. This praise took a massive halt after Simmers suffered from a mini stroke, taking a large toll on his physical and mental well-being. Around 3 months after his mini stroke, the Times had a meeting with Simmers, saying that his columns have not been up to par with their standards and reduced his columns from 3 times a week to 2 times a week. 2 weeks later, Simmers was suspended for working alongside another publication. He was terminated 10 days later. On October of 2013, Simmers sues the Los Angeles Times Communications LLC for age discrimination and violation of the California Fair Employment and Housing Act. The question is, was plaintiff terminated due to his decline in performance and several supposed breaches of the Tribune Business Code of Conduct, or was there age discrimination and violations of the California Fair Employment and Housing Act by the defendant? The conclusion is inconclusive. In 2015, the jury found in favor of plaintiff and awarded him with $2.1 million in economic damages for, quote, harm caused by his constructive termination, and $5 million in non-economic damages, totaling $7.1 million. Both parties appealed. In August of 2019, the jury awarded Simmers $15.4 million in damages against the newspaper for age and disability discrimination. This was then overturned in December of 2019 by a Los Angeles judge, saying that the amount was not justified due to misconduct by the plaintiff's attorney and that the award was excessive. That was all the case we have for you today. Thanks so much for listening.
Hello. That was about
There you go. Oh shit, so recording.